This quote I've written on the board: focus on mercy, not rules. I want you to tell me where you think, it was recently in the news, a public figure recently uttered the statement in the news. And I wonder if you could guess who it is. I'll give you a hint. He's a very unlikely ally for my position and for humanists in general. The Pope. You got it. The Pope is taking unexpectedly liberal positions lately. I think he's getting into trouble over it. But I was really fascinated by this statement that we should be more concerned about mercy than rules. It's not typically what you expect from the Catholic Church. We're talking about something I think is extraordinary in our legal system, and something that's quite important, but not well known at all. Anyway, in December of 2011, Julian Heiklin, a retired chemist, as it turns out, I'm one myself, and a social activist, was arrested on the steps of a New York City courthouse. He was handing out pamphlets, and he was arrested with criminal charges placed against him. So what was his criminal act? Was he advocating terrorism or sedition or violent overthrow of government? Was he distributing child pornography or advocating some other awful crime? Hardly. He was handing out pamphlets and explained that jurors have the unquestioned right to render any verdict they wish to render, a verdict that goes against the law if they so wish. This is something known as jury nullification. In effect, the jury nullifies the law, refuses to follow the law in rendering a sentence. The information on Heiklin's pamphlet was true. He gave an accurate explanation of this absolute right of juries, but it was viewed as a criminal act. The authorities in New York viewed this knowledge as forbidden knowledge. As you will see, authorities in Canada do that as well. That idea will be one of the themes of the talk. One is focus on mercy, not justice. Another is forbidden knowledge. What sorts of knowledge should be forbidden? I should say at the outset that I'm one of those that, obviously if I'm associated with a free thinking group, I take the view that most knowledge ought not to be forbidden by authorities. Maybe plans for making atomic weapons, certainly child pornography because it involves the exploitation of children. But in a society built on freedom of speech and freedom of expression, areas where knowledge is limited and forbidden ought to be very few. Another theme of this talk is social justice. By social justice, I mean equality, compassion, and fairness in society, supporting minorities and the poor in search of greater social equality. Some of our political leaders have been better in this regard, in regard to social justice, than others. I'd like to talk about John Diefenbaker, who was our 13th Prime Minister. Not so well remembered for his interest in social justice, but he was one who was. He took a strong stance against apartheid in South Africa, and that led to South Africa leaving the Commonwealth of Nations. He appointed the first female cabinet minister and the first Aboriginal Senate member. He granted the vote to First Nations and Inuit peoples. He took actions and passed legislation that helped the minorities and the poor. A childhood friend of mine actually worked as Diefenbaker's executive assistant in the 1960s, probably why I like to talk about him. And he told me a story about Diefenbaker when he first visited Churchill in London. And Churchill invited him in, of course offered Diefenbaker a drink. Diefenbaker declined. So Churchill said, "You're a teetotaler, are you?" And Diefenbaker allowed, yes, he was. So Churchill looked at him and said, "Well, are you a prohibitionist?" And Diefenbaker said, no, he wasn't. Churchill said, "Well then, you only hurt yourself." Now, unfortunately, when politicians make bad laws, pandering to narrow constituencies, they don't hurt themselves at all. They hurt other people, especially minorities and the poor. In the name of getting tough on crime, our Harper government has been solidifying support with its right-wing base by passing regressive crime legislation. His latest, Bill C-10, the so-called Safe Streets and Communities Act, was passed on March 13, 2012. And this specified a drastic increase in the number of mandatory minimum sentences for drug offenses, among other things, but that was one thing that was particularly objectionable. The result has already been that more people are in prison, but no decrease in drug use, just as in the American war on drugs, where they passed similar, even harsher legislation. We were warned about the futility of legislation like this by U.S. officials who had actually been involved in drawing up the original American legislation on the war on drugs. And they'd learned their lesson. They said, when you start going down this road, building more prisons and sending people away for long periods of time, you convince yourself that this is going to deter people, but you've made a colossal mistake. Bear in mind, for most part, these are victimless crimes, that the new laws disproportionately punish the minorities and poor. The more people in prisons will ultimately mean more criminals on the streets, because prisons are schools for crime. And the mandatory minimums mean that the law will be an even more of a blunt instrument than it already is. And all of this is going on in spite of a general decrease in crime across both countries. Now, humanists want this world to be one characterized by justice, fairness, and human decency. Humanists think this is the only world we have and will ever have. So here and now is where we must find these things. But we find a justice system moving in the wrong direction. We see a system with diminishing latitude for judicial discretion and mercy. Most humanists I know were appalled by the treatment of Robert Latimer. I think Doug mentioned that I'd previously done a book on Robert Latimer. Latimer spent 13 years of dedicated care for his daughter, whose brain was severely damaged at birth from oxygen deprivation. She led life, little girl led a life of uncomprehending pain. Her mind never progressed beyond that of a four-month-old baby. And she's in constant pain because of uncontrolled spastic motions of her body, which caused joints to dislocate. By the age of 12, she'd already lived longer than most children of her condition. And she was facing new operations and increasing pain. It was a very difficult situation for the Latimers. Robert couldn't bear it any longer. Even though she was likely to die soon, he couldn't bear to see her suffer, increasing suffering over the next period of time. So he, of course, ended her life. Then he went through 7 years of legal proceedings, spent 7 years in prison, spent 3 years on day parole, which is when I met him. No, actually, I met him in prison before day parole. Spent a lifetime, he now is spending a lifetime on parole. It lasts for life, it's a life sentence, with all the restrictions that entails. All this, even though his judge and his jury, both of whom saw all the evidence, listened to all the witnesses, wanted at most a 1-year token sentence. But the justice system was unable to find a way to dispense justice in this case. A real option in this case might have been to find him not guilty, even though he obviously was technically guilty. An option was jury nullification, going against the law when strict application of the law is unjust. But Latimer did not have Julian Heiklin handing out pamphlets outside the courtroom as the jurors came in. They did not understand that this was an option. But why did Latimer's lawyer then not tell them that it was an option? To understand what happened here, we need to look at the trials of Henry Morgentaler. I think you're probably all familiar with Morgentaler. He's a hero to many of us. He risked his own safety to help desperate women. He witnessed the desperate plight of women in Quebec in the early 70s when he was practicing as a general practitioner. At that time, of course, according to Canadian law, abortions were deemed to be illegal except in certain special circumstances. So Morgentaler gave a speech advocating women's right to choose, public speech. And many women came to him afterwards pleading for help because they couldn't find it anywhere else. He turned them down at first, but he felt very guilty, and he saw some of the results of botched abortions. So Morgentaler opened an abortion clinic in defiance of the law. This is in Montreal. He was left alone at first by the Quebec government, but he eventually was raided and brought to trial. There was no question of his guilt. He openly admitted to performing over 5,000 abortions. And in open defiance of the law, he even carried one out on television. Still, he was found not guilty by his jury in a very famous case of jury nullification. Just as an aside, in a surprising action, the Quebec Appeals Court reversed the decision, and Morgentaler was sent to prison for some time. He spent 10 months in prison. It was very, very hard on him. After this, the criminal code was changed. It's called the Morgentaler Amendment to the Criminal Code, and it says that a judicial body, appeal board, can't overturn a jury decision any longer. That's the Morgentaler Amendment because of the unfairness of that particular event. So a jury wouldn't send him to jail, but the appeal board at that time could and did. He was, after the 10 months, he was prosecuted 3 times in all in Quebec, brought to trial 3 times, 3 times found not guilty. He used to say that no jury would ever find me guilty. The Quebec government changed around this time, and the more socially progressive PQ party came into power, and they refused to bring any more prosecutions against Latimer. Sorry, I keep saying Latimer, Morgentaler. They declared the abortion law unenforceable and recommended that the federal government change the law banning abortion. That didn't happen, but the clinics continued in Quebec. In the early 80s, Morgentaler decided to up the ante and set up clinics in Toronto and Winnipeg. He was prosecuted again in Ontario and Toronto. This time his lawyer was the eminent Morris Manning, who actually has written a preface to my book. I'm sorry I don't have the book here. It was supposed to be here today, but it's not here. But there's a flyer about it on the table. Certain complications in the Ontario case made a prosecution a guilty verdict more likely than in Quebec. I won't go into the details of that just now. So because of that, Manning needed to provide a very strong defense. So he said this to the jury. He said, "It is up to you and you alone to apply the law to this evidence. And you have a right to say it shouldn't be applied. You're stating the jury can, if it so wishes, decide not to apply the law." He was found not guilty again, this time by the Ontario jury. Jury nullification is based on the idea that juries must be fully independent and come to any decision they wish to come to for any reason. They need not explain themselves. In fact, in Canada, they're not allowed to by law explain why they came to a decision. And they cannot be punished for their actions. It's not well known, but it's an absolute, very important, uncontested right of juries wherever legal systems are based on English law. It stems from the 1670 trial of William Penn in London, England. Penn was a famous Quaker who was prosecuted for preaching in public, something other than Anglicanism. He was tried in the Old Bailey courthouse in London, and his jury refused to find him guilty. The court was outraged. They sent the jurors to prison without, quote, meat, drink, fire, or tobacco. And they said to the jurors, "We will have a verdict," by which they meant a guilty verdict, "or you shall starve for it." Finally, when the jury continued to refuse to come up with the verdict they wanted, they were given heavy fines. The jurors were given heavy fines and imprisonment until the fines were paid. I think the fines were equivalent of a year's salary for the jurors. One of the jurors contested this treatment, a famous juror named Edward Bushell. And he went to the appeal court, and the appeal court examined this issue, and Justice John Vaughan made the following ruling. He said, "The jury must independently and indisputably be responsible for its verdict, free of any threats from the court." This has since been a cornerstone of law. You can't force juries to come to any particular decision. And that was clearly established in this Penn situation, and it's held true ever since. That is what Manning told Morgentaler's jury. "It's up to you and you alone to apply the law to this evidence, and you have a right to say it shouldn't be applied." The Morgentaler trials were a great triumph for social justice in Canada. The acquittal of Morgentaler for acts of human kindness, which happened at the time to be illegal. The Morgentaler trials led to the Supreme Court decision in 1988 to decriminalize abortion. It meant that women in Canada no longer needed to be held hostage for life because of a brief sexual encounter, and no longer had to resort to backroom abortions. This whole affair was a great triumph for Morgentaler's courage, Manning's defense, and the idea of jury nullification. I was talking about the Morgentaler trials to Latimer when I was working on that Latimer book. And Latimer didn't know much about it, but he said something about, well, his lawyer told him there was something good about it and something bad. That surprised me because I couldn't think of anything bad about the Morgentaler judgment, the Supreme Court judgment, unless you were an anti-abortionist, of course. But if you supported the idea of abortion, then it seemed to be just a very good ruling, very good thing. One way in which the world was made significantly better, at least in Canada. But so I thought, well, I wonder what he's talking about. So I looked into that Supreme Court judgment, the 1988 judgment. And I found a little-known judicial aside that essentially did ban future uses of the Manning defense, the defense that I quoted you. This is not a ban on jury nullification. That would destroy jury independence and set the clock back to the 17th century. But it was a ban on defense lawyers mentioning the possibility of jury nullification. That is why Mark Brayford did not mention it to Latimer's jury. That was Latimer's bad thing, and it was indeed a bad thing for him, because his jury, though sympathetic, felt obliged to find him guilty. They thought they had to. And Mark Brayford could not tell him about the possibility of nullification. Latimer was harmed by the Supreme Court decision, and many would agree that the idea of justice in Canada was harmed as well. Juries are prevented from voting their consciences, which is theoretically their right, simply because they no longer know that they can do so. So be careful if you throw yourself on their mercy. So why did the Supreme Court do this? I looked into that at some length. I found widespread judicial antipathy toward the idea of nullification. A famous case illustrates this, the case of Grant Krieger in 2005 in Alberta. He was prosecuted a second time for growing and selling marijuana. He had a license to grow it for himself because he had some kind of illness. And he was selling it to other people who had a similar illness. And that was deemed to be illegal. He only had a right to grow it for himself. But the jury was very sympathetic with him. And in his first trial, in the early 2000s, they found him not guilty in jury nullification because he was technically guilty. But this time, in 2005, the judge, Justice Shrumka, was not about to countenance jury nullification happening in his court. The trial proceeded, and at the end, he gave his instructions to the jury, and he said this. He told the jurors, retire to the jury room to consider what I have said. Appoint one of yourselves to be your foreperson, and then return to the court with a verdict of guilty. Now, Shrumka doubled down on this. It wasn't just a slip of the tongue. He was questioned by some jury members. One of them happened to say, we only have two choices here. Shrumka said, actually, you have only one choice, which is guilty. This is an extraordinary action by a judge, entirely undermining the role of a jury. If a judge can do that, tell a jury what to do, then why have a jury at all? What's the purpose of a jury? This was appealed. Astonishingly, it went to the Alberta Appeal Court, and they upheld the decision, which is one of the strangest. You could see a sort of rogue judge making a silly and illegal decision. But the Alberta Appeals Court supported Shrumka's decision and Shrumka's action. I write about that in the book. It's a very strange business. He went to the Supreme Court of Canada, and it was said to be the most expected decision in the history of the Supreme Court that they couldn't support Shrumka's action. They couldn't support that conviction. And so they overturned the decision. And this illustrates, again, it's a case that illustrates the need for juries to be independent. But I wondered, I looked into what are the reasons? I mean, was I missing something in all of this? Why are judges, not just Shrumka, so opposed to the idea of nullification? For one thing, they're trained to have overriding respect for the law. It's good to have respect for the law, and I talk about that in the book, but judges are quite obsessed with following the law. They tell juries that they will interpret the law for them, which is correct. They do interpret the law for jury members. But what they don't tell them is you don't need to follow that law. They never tell them that. They just say, this is what the law is, and your job is to assess the facts. They don't tell them that you have the right to go against this law. They never tell them that. And it's because of their obsession with the law. Now, there are objections that they bring up. In the Supreme Court decision, there were a number of objections which I looked at very closely. There's a general objection to the idea of lay people determining if the law is to be applied. But that's the basic idea of juries. Ever since the Magna Carta in 1215, the idea was to take away decisions regarding criminal convictions from authorities and put them in the hands of lay people. Some argue that nullification is undemocratic. The laws are made by legislators, and if you want to change the law, then you should take it to the ballot box. But this is not a practical suggestion. Even if one was, and even in the unlikely case that one was successful in getting a particular law or bothersome law changed or modified, laws are still inherently inflexible. Can't cover every situation. And nullification is allowed by our democratically determined legal system. We are legally permitted to have this small way, jury nullification, where ordinary citizens can effectively challenge an unjust law. Legislators could ban nullification, but they have wisely decided not to do so and are not likely to do so. So it is a legal procedure. Some people argue that jury nullification will lead to legal chaos and loss of respect for the rule of law. But this is not true. The Morgenthaler case led to more respect for the law, not less, because the law in the Morgenthaler case found a way for justice to prevail over the letter of the law, over the rules. The trump card against nullification is always racism. The problem of having, for example, a racist jury which refuses to convict white murderers for killing a black man. That has happened in the American South, not in Canada so far as I know, but in the American South. Most famous case was that of Emmett Till. Do you remember that case? Hearing about it? He was a black boy, 14-year-old black boy who lived in Chicago and went to visit relatives in Mississippi. And he made the fatal mistake of whistling at a white woman. The white community became very outraged by this, and a couple of days later, the woman's husband and another white man took Emmett Till out and killed him and dumped his body in the river. Everyone knew who did it, but his jury, his all-white jury, refused to convict the two murderers. This is a terrible example of nullification. What are we to say about that? Well, for one thing, it was not a jury of peers. It was a jury of all white people because blacks were not eligible, they weren't on the voting list. For another thing, would a ban on mentioning nullification have improved things in this case? Justice here was a lost cause. The racist judges, sheriffs, prosecutors, a racist society, it was a societal pathology that discredited all aspects of the legal system, not just nullification. The Till jury would have found any excuse to not convict these two white men, regardless of what had been told. They seized upon a pretext. The sheriff in the community claimed that the body that was found in the river was not that of Emmett Till, in spite of the fact that his mother identified his body and his relatives did as well, and he was wearing a ring that his father had given him. But the jurors, these malevolent jurors, seized upon this as a pretext for finding the two defendants not guilty. So it wasn't overtly nullification, which is where you openly go against the law. They were claiming that they were following the law because of uncertainty about the body, but it was a pretext, silly pretext. But this is clearly a terrible incident. It wasn't just terrible nullification. It was terrible from all aspects. Now, but it wasn't in the end such a bad result. The boy's life was taken, nothing could change that. But otherwise, this miscarriage of justice, it was called a trial, miscarriage of justice, actually had some positive outcomes. One was the two murderers had a very miserable life afterwards. The blacks would no longer deal with them, work on their farms, and buy goods from their stores that these two men had owned. So they didn't. They had their own kind of punishment. And Till himself became a symbol for the American Civil Rights Movement. And he was cited by Rosa Parks when she defied the bus driver at the beginning of the movement. She cited it as a reason for her defiant action. So there are positive things that came out of this this case. What I often argue is that it's not the most terrible thing in the world for guilty people to be turned free. It's much worse for innocent people to be found guilty. It's William Blackstone, a famous English jurist, used to say, it's called Blackstone's formulation, that it's better that 10 guilty go free than 1 innocent get punished. And that's sort of the spirit of English law, where it's a far worse thing. And it's usually not such a terrible thing if as in this case, because of a distorted law system, legal system, that the defendants went free. Trial actually had positive outcomes. Now, are these arguments sufficient to suppress the suppression of nullification that I mentioned earlier? As with any principle of law, there are good and bad things about jury nullification. Habeas corpus, for example, can result in the release of dangerous prisoners. Requiring rules for evidence can result in blockage of key evidence that could have a strong bearing on the court's decision. All legal principles can and have been abused. We do not abandon them, though, if they're basically good principles. And by making jury nullification a secret, as the Supreme Court has done, a tool for social justice like habeas corpus, like rules for admission of evidence, has been largely removed from our courts. The Supreme Court has harmed people like Latimer, who are no longer likely to have the benefit of a sympathetic jury. I want to just quickly run over the reasons, some of the reasons. These are all elaborated on much more in the book, but I want to say why it's essential that we continue to have nullification and support the open countenance of nullification. Most obviously, if nullification is a fundamental right of juries, as I believe it is, then they should know about it. It makes no sense to have a right which in effect is then denied by making it secret. Another argument is that suppression of nullification is a violation of the Canadian Charter of Rights and Freedoms. That charter says that those accused of indictable offenses have the right, this is the wording, to the benefit of a trial by jury. But as I talked about earlier, there is no benefit of a jury if the jury is not independent. If the jury must take the judge's bidding, then it's of no value. So there's no benefit of a trial by jury, then that seems to be a violation of the charter. It's also, I argue, discriminatory to not tell juries about this right, because some juries will, in fact, know about it. You know, if any of you now happen to be on a jury, you will know about it, but other juries won't. And that seems to be then some defendants will have the benefit of that possibility and others will not. That seems unequal treatment under the law and discriminatory. It also seems to me to be a violation of the civil liberty of entitlement to the best possible defense. If in the case of Latimer, the only possible defense, only real defense, was really that, yes, I did it, but I throw yourself on the mercy of the courts and don't find me guilty. But he wasn't allowed to use that defense. That seems a violation of that civil liberty. And the suppression of nullification undermines the basic purpose of juries. If juries are not independent and are merely, as judges want to say, assessors of facts, there are much better and more efficient ways of assessing the facts in a trial, like a panel of judges who are experienced in such matters. If juries are not, in fact, independent, then there's a strong argument for getting rid of them. That's happened in some countries like India, Singapore, and South Africa. The future of the jury system itself, I believe, ultimately hangs on this question of independence. So we've lost this tool for social justice and mercy. A tool that a loss which disproportionately hurts poor and the minorities. It's a loss by which ordinary citizens can fight injustice and grant mercy. There was one recent breakthrough in 2012 in the state of New Hampshire. It specifically addressed this matter in a new law. It specifically permits lawyers to plead for jury nullification. It's the only place I know where it specifically allows that. One of the positive results of that is that prosecutors are now less inclined to bring forward minor cases of drug violation which have severe penalties because they know they'll probably be nullified. However, most states still try to suppress the idea, as does Canada. This tool of social justice has been turned into forbidden knowledge. Now, I mentioned earlier that the Harper government in 2012 passed the Safe Streets to Communities Act, introducing problematic new mandatory minimum sentences. Previously, in 2008, they passed another crime bill called the Tackling Violent Crime Bill and included this section. Every person in any place who possesses a prohibited loaded firearm or unloaded with ammunition readily accessible is guilty of an indictable offense with a minimum of 3 years for a first offense. Now, in some ways, this doesn't sound like a bad idea, but when you look at it in practice, you see some of the applications. A recent one was a case, most famous case was that you may have heard of Leroy Smickle, unfortunately named young black man, with a job, a fiance, and a child. And he happened to stay at a cousin's apartment in Toronto. The cousin was away, but Smickle was there, and he found a loaded handgun in the apartment. And so he decided to pose in front of the computer camera with the handgun in his underwear for some reason. He wanted cool pictures. Just as he was doing this, the police broke down the door, looking for the cousin. Smickle immediately dropped the gun, but he was arrested and charged under the 2008 crime bill and was liable for 3 years in prison. Justice Anne Malloy, Ontario Justice, just thought this was crazy. She thought, I can't give this boy, he's going to ruin his life, send him to prison for 3 years. She gave him his time served, which was some number of months, but did not have him go back to jail. But she defied the mandatory minimum specified in the violent crime bill. This is currently under appeal. It's Ontario Appeal Court, of course, has taken it up and is currently looking at it. They heard it, I think, in February. Decision is expected at any time. But it took a very courageous decision by this judge to go against the law. This is a case of judicial nullification. But open recognition of jury nullification would provide another way of dealing with these legal inflexibilities that are being built into the law by the Harper government. We're going to need this so that ordinary citizens can fight against repressive laws. The actions of the Harper government in bringing in tougher crime sentences, especially mandatory minimum sentences, did not hurt them. But these actions have hurt others and will continue to hurt others, especially minorities and the poor. This is the opposite of social justice. And the Supreme Court of Canada has exacerbated this social injustice by forbidding of giving the crucial information to jurors, perhaps the only means by which ordinary citizens can fight back. We have increasingly harsh and unjust laws at a time when jury independence has been effectively suppressed by the Supreme Court of Canada. I don't know how the situation can be changed, as some possibilities are discussed in the book. But now you know about this secret. Now, should you find yourself on a jury, you are empowered to fight against this conspiracy of silence. Thank you.